year 2024 was a major year for immigrants because of the drastic immigration rules which were introduced by the UK government. So if you are on a student visa or you're on a graduate visa, skilled visa, carer visa or dependent visa, make sure to watch the video till the end, as I'm going to talk in detail about all the changes which happened this year and some of the common questions that you guys had been asking me from last 1 to 2 months in my different videos. Today I have a special guest, Adam, who is one of the solicitors in the UK, and we are going to discuss all the details and how you can avoid those mistakes in the future. So if this topic is of any use to you, make sure you watch the video till the end. But before we start, a quick introduction about myself for my new audience. My name is Sarika and I have been living in the UK for the last 14 years. I work full-time in IT, and during my free time, I make YouTube videos. I have two good news to share with you guys as well. First is about study abroad service. You guys already know that I can help you study abroad in any of these listed countries. You simply need to fill the form which is provided in my video description and pinned comment, and my team will reach out to you soon. If you don't hear back from them, you can send me a direct email on yourknowledgebuddy@gmail.com. Second update from me, I'm launching a job assistance service to help you find a job in the UK. I know many of you are struggling to find jobs and need more help navigating the UK job market. I'll assist you from start till the finish, including job searching, networking, and interview preparation. This is a paid service and I will take only a few students to start with. I offer two packages, one for groups and for one, which is more expensive, one-to-one consultation. If you want more details, you can email me with your CV at yourknowledgebuddy@gmail.com. So without any further delay, let's get started with today's video by introducing you guys to Adam. Hi Adam, welcome once again to Your Knowledge Buddy. And if you don't mind, can you please introduce yourself to my audience, please?
Thank you so much for having me. So my name's Adam. I'm an immigration advisor based in the UK, and it's a pleasure to be here.
And if my audience wants to reach out to Adam, you can do that by the links which is provided in my video description and pinned comment. Adam is too shy to even talk about saying, hey guys, you can reach out to me for any kind of inquiries you have. So I'm going to do that part. Okay, so Adam, today's topic is about all the recent changes that had happened recently, say from March this year. I know this year is full of changes actually, for say skill visa or student visa or carer visa or for immigrants. It was not, I will say, a very positive year for them. Of course, the goal of the UK government is to control the net migration because the numbers are quite big and alarming, right? So if you have to summarize the key changes which happened from start of this year, what will it be?
Yeah, so two significant changes. Perhaps the most significant was we saw all of the job codes historically, so the SOC 2010 occupation codes that were for the skilled worker visa and the shortage occupation list, all of that was essentially sort of shifted over to a new set of codes called the SOC 2020 list. And along with that change came a huge increase in salary for many, many people, and a huge increase in the threshold for people to be able to qualify for the skilled worker. So that's one particular thing. Another very difficult one that we had earlier this year in March was the care workers and senior carers dependent ban. So basically anybody who is applying as a care worker or a senior carer for the first time since after March this year, technically speaking, they are not permitted to bring dependents. In my opinion, it's a very harsh rule.
The third rule, which I know, was about stopping the shortage occupation list and bringing the new immigration salary list, which was again a big surprise for me because they took out almost all the major jobs I knew where they hired immigrants. Yeah, I don't know.
Yeah, it's much smaller, isn't it? It's much smaller than the old one.
Just 22, I believe, including Scotland's. Yeah.
Yeah, so they're hoping, we have been told that they'll be doing a more formal review by the end of this year. Let's see what happens. I don't know whether the result of that will be that they add any more codes. I know there's been a lot of, establishing a new body, because we all know establishing a new government body, how well that solves things. But anyway, that's my cynicism coming out. But hopefully we'll just have to see what the codes show us at the end of the year.
Correct. So, Adam, most of my audience are students who are immigrants who are watching the video. So, for students, I know the salary threshold that you mentioned, there was an increase in the salary threshold this year. It's not exactly the same for them. So, there's something called as new entrant. Can you just explain that to my audience, please?
Yeah, so really the flicker of hope for students and graduates in terms of the recent hike in salary is the new entrant provision. Now, if you're a recent student or graduate, you can be paid a lower salary than the super high threshold for a limited period of time. So based on the new rules, if you're applying for a skilled worker for the first time after the rule change, you're looking at being paid at least £30,960 per year and £15.88 per hour. The reason that's significant is that you need to meet both. Okay. Mm-hmm. The 30,960 is based on 37 and a half hours average working a week. Now, the other thing about the new entrant is that it's time limited. Mm-hmm. That's the only drawback. So you get a low salary, but it's time limited. So what do I mean by that? Basically, there's a 4-year window that opens at the beginning of your grad visa, or if you're switching straight from the student visa, it opens once you switch to the skilled worker visa for the first time. So you get 4 years in that window. So for example, if you were to switch at the end of your graduate visa, you could only be paid the new entrant salary rates for those 2 years. Now, another thing that's really important, and this catches a lot of people out, is that your certificate of sponsorship and your visa itself have to match that period of time. You cannot get a longer visa or COS and then just promise the Home Office that you'll change the salary later. You have to have a specific COS and a visa for that time period. And then once you come to the end of that, you would need another COS and a visa. But of course, you would need to score points under a different salary option.
So the maximum year a new entrant at once can be applied is for 3 years, right? Because they cannot get a 4-year visa at once. So say I'm on a student visa and I finished my studies, my results are out and it's after the end of CAS letter. It means I'm eligible to switch my visa to a skilled visa. On that day when I do, there's nothing called as 4 years visa. So it means if I'm switching, I'll be getting only 3 years of maximum new entrant salary discount. Right, Adam?
So just to clarify, so you can technically get a 4-year visa. Now, when it comes to 3 years and 5 years, those tend to be the most popular durations, and I'll tell you why. It's because those are the most cost-efficient times.
Right.
When you cross the 3-year threshold, the visa fee almost doubles. Mm-hmm. So what that means is that you get the most for your money if you get a 3-year visa, and if you get the most for your money if you have a 5-year visa. However, it is perfectly possible to have a visa for 1, 2, 3, 4, 5 years, right? So if you're switching straight from the student visa, so let's say within the last 6 months after your course, you secure a sponsored role, you can go straight for the 4 years. You can just do that all in one. And then of course, if you switch to the graduate visa, then that 4 years, the clock starts ticking. Mm-hmm. So depending on what point you switch during the graduate visa, that determines how long you get. But the easiest way to figure it out is chart 4 calendar years forward from the start date on your graduate visa, and that's your cutoff.
I didn't know that the companies gave like 4 years of straight sponsorship. What I have seen, like you said, the common ones are 1, 2, 3, or 5 maybe. I've never ever heard that any company, they had given like a 4 years visa. So I thought maybe 4 years visa doesn't exist. And for new entrant, because that's allowed for new entrant, discount is allowed for 4 years. I thought if a company is taking a student and with a new entrant, they can issue a COS only for 3 years. And again, next year they renew it for another year. And next year, without the new entrant, for the last year, they have to get into a full-fledged salary without the discount. I thought that's the step they have to follow. Okay.
Yeah. So it is possible if the circumstances allow that they can go for the 4.
Okay, that's a new information for me. So thank you. And I hope even my audience is learning from you, Adam. Okay, the major confusion now, I'll tell you what my audience is at least facing. They are facing about the supplementary jobs. What are allowed versus what is not allowed. The first question is new rule versus the old rule. Was there any change what people could do in the old rule, people who are on a skilled visa versus people who are on now new rule for skilled visa?
So the definition of supplementary work has been redefined in terms of the rules, and it's been redefined for everybody who's on a skilled worker visa, whether they had it before the rule change or whether not. Okay, so to find this, you would go to the immigration rules and you search introduction to the immigration rules. And there's a list of basically definitions. So if you scroll down through those and you find supplementary work, the definition, what you will find is supplementary work is permitted, and it's defined as any job code in tables 1, 2, or 3 of appendix skilled occupations. That's important, because if you type in those words, you'll get it on Google. Appendix skilled occupations. Any code under tables 1, 2, or 3, or the immigration salary list. Okay. But you must not work in any code that's in table 6 of appendix skilled occupations. So one thing that's confusing many, many people is that there has been a delay in the Home Office updating various documentation and various alerts. For example, someone who's held the skilled worker visa since before the rule change, they run a right to work check because they want to do supplementary employment, but it's still saying shortage occupation, same code, otherwise not permitted to be able to do supplementary work, which of course is outdated. But it kind of reinforces this idea that there's a two-tier system, that there's separate rules for people before and separate rules for people after. However, according to the rules, it applies to everybody. The main thing is it's outdated prompts and alerts for skilled worker visas who've held it continuously since before the rule change.
Okay, that's helpful. So I think if people can take a note of that table 6, they should be careful that they are not working in the job of table 6 and the others are where they are permitted, right? Good.
Yeah, absolutely. Absolutely. And another thing as well, it's especially important to be looking at table 6, because if you look through table 6, the ironic thing is that a lot of those roles are the kind of roles that you would find easy to do in your spare time. Like they're not too stressful, like it's like barista, or one of them's an ice cream salesman, which I kind of made a joke. Like if anybody comes up to me as an international and tries to sell me an ice cream, I promise I won't report you to the Home Office. Anyway, that's an aside. But a lot of the jobs, it might be retail assistant. It's generally lower skilled jobs.
Correct.
But they're exactly the kind of roles that would be very easy to do outside your main job, because obviously your main job is quite stressful. But you just need to make sure you look through those just to double check that you're not in one of those codes. That's just another tip there.
Can I just ask one question? I remember few people had commented in my previous video. They were asking, can they start their own business, like an online business? Say IT people can start their own business, like an IT consulting, or someone who wants to do an import and export business, creating their website and managing it. So are those kind of work allowed or not?
Yes, absolutely. So you won't find it in the immigration rules, but you will find it in the overview section of the skilled worker visa. So there's 3 different places you can go to get information. So one is the rules themselves. So that's the law in black and white. You've got the guidance, which is how the Home Office interpret the rules. And then you have the overview, which is like the super basic general overview. Normally I say to people, go to the rules and the guidance first, because the overview is so basic, it throws people off. However, you will find in the overview, the skilled worker visa overview, if you go to taking on additional work, I think that's the tab. It references that you can undertake employment or start your own business. Now, there's a few ways that you can do that in the UK. So you can either set up as a limited company director. So that's essentially where the business becomes a separate legal entity to yourself as a person, right? And then you can set up as self-employed, which is slightly different. There's no separation between you and the business in terms of taxes. So everything's coming in, all of your income's coming in and your revenue's going out from yourself. In contrast to the limited company, where the money goes into the company, and then obviously you can control how much you receive. Now, the reason I mention that is because if you're on a skilled worker visa already, you're already receiving a salary via PAYE. So you've already met the minimum tax threshold, the allowance of 12.5k for the year. So what that means is if you're self-employed, it's not very tax efficient, in my opinion. I would generally recommend, if you want to do a side business, to set up a limited company, because you can either keep the profits in the company and then just pay the corporation tax and then withdraw it at a later time, or you can choose how much salary you receive, so you're staying within a certain tax bracket, or you can pay yourself in dividends as a shareholder, which is it's taxed differently. And the reason I recommend that is you might have a bit more control, and it might be a bit more tax efficient if you wanted to do that. But that's just my opinion.
Okay, thanks, Adam. Another question which I had written for you is from one of my audience who had asked me initially. So say this person switched from student visa to skill visa, and he's into construction industry. As you know, during the winter month, the jobs in the construction industry, it goes down, yeah, because of the harsh weather outside. You don't have too many jobs in the construction industry. So this company who sponsored him, there were certain hours which he was supposed to do with them, say 35 hours maybe per week. Now, what happens if the company says, hey, I don't have a job for you during 2-3 months, but on the paper, they have to get that minimum hours, right? Then only they will be satisfying the rules for skill visa. And they're saying we don't have it now. And they're genuine companies. So how do people tackle that?
Yeah, so according to the rules, the information provided on the certificate of sponsorship, right? So the weekly hours, the salary, etc. That's the absolute baseline. So that's what the employer is committing to paying, week in, week out, month in, month out. Now, when it comes to the rules, there's certain exceptions where you can be paid less for a certain period of time. So it might be statutory maternity or paternity pay, it might be sick leave. There's a list of sort of government sanctioned absences that are permitted. Outside of that, generally speaking, you can, if it's permitted by the employer, you can generally have up to a month at the most, either paid less or with no pay in any calendar year. And the reason I say that is because if you go to Part 9 of the immigration rules, and it says reason for cancellation, and one reason for cancelling someone's visa can be if they've been absent from work without pay or reduced pay for more than a month in a calendar year, where it's not been for one of those permitted reasons, for example, maternity or paternity pay or sick pay, for example.
So will there be any impact when they apply for ILR?
I guess this would depend on at what point it occurs. I also get people asking me the question as well. I've been made redundant. I've lost my sponsorship. I've maybe had a 6-month gap between one employer, and I've just found another one. The key is you need to ensure, obviously, that your sponsorship is ongoing at the point of applying for ILR. Now, if, like I said, there was a reason why there was reduced pay or no pay for that extended period of time, I tend to say really just honesty is the best policy. So just disclose it. It's better for you to share it rather than it being found out, being questioned about it. Do you know what I mean? That's that's my philosophy. So will it affect your ILR? I mean, it shouldn't do, technically. I think what I would recommend is, obviously, if there's been anything like that, then just to disclose it, that it's happened. Also, sponsors have a duty to notify the Home Office. So, for example, if a worker is not receiving the pay, or they're on reduced pay for that extended period of time, then it's actually technically a responsibility of the sponsor to notify the Home Office. And then it's up to the Home Office to decide whether they cancel the permission or not.
Okay. I didn't know that they have to inform the Home Office. Okay.
Yeah.
Is there any common question that you get from students based on all the recent changes that you want to share with my audience before I let you go, of course?
I think I identified a lot of the stuff in terms of the new entrant. So I think that a lot of common questions, I think I tried to cover in that. I guess the key, I would say, with students is being fully aware of your working permission. So making sure that you're sticking to the 20 hours per week during term time. So making sure you've got a copy of your exact term dates, because not a lot of people know this, but actually, if you work more than 20 hours a week during term time and you're caught, like that can be a reason for being pulled into detention. and having your visa potentially cancelled. Like, it's pretty brutal. So, and also your employer can be fined because that's treated in the same way as employing an illegal worker. So they can be fined 5 figures. So make sure you've got that right. Know when your course end date is. You can start working full time at the end of your course. Once you finish that, the rules recommend that you don't sign a permanent contract with an employer until you've at least submitted your graduate visa application or you've submitted your skilled worker visa application.
Wonderful. Thank you very much, Adam. I hope this video is going to help all the immigrants, students, or people who are on skilled visa. Thank you very much for sharing your information with my audience, and anyone who wants to take advantage of Adam's service, you can reach out to him through the link which is provided in my video description and pinned comment. Thank you, Adam. Thank you, and have a nice evening.
Thank you so much for having me. Thank you, everybody. Cheers.